wonderful and awesome that you're here to learn more about potentially attending law school. My name is Marion Humphrey. I'm from Little Rock, Arkansas. I am a 3L at the University of Arkansas, born and raised in Arkansas, and this is where I wanted to do my legal work. I attended law school after a number of years outside of my undergraduate experience at Davidson College in North Carolina. I worked for a progressive nonprofit organization in Washington, D.C., and called People for the American Way for 3 years. I followed that by working for a labor union for 2 years. Then I moved back to Arkansas to really take the work back home where I thought it really needed to be. And in doing that work, I decided that it was important for me to maybe approach the change that I wanted to see from a perspective. And so I say all of that to really encourage people to really consider maybe if this isn't your year to go to law school, taking time off, getting experience, and then reaffirming that interest in approaching applications to law school, because I really think it helped me shape and consider what I really wanted to do. Beyond that, I think it's important to just be yourself and really support your own interest in the law. The law gives you an opportunity to really approach a lot of different issues and concerns and problems that you might face on a personal level, but also those that are really important to people in your community. And I know that on a personal level, a lot of the issues that we see nationally affect us all, particularly Black folks. I was recently the victim of a very bad police stop, and it was a 2+ hour stop in the middle of COVID, where I was handcuffed and bent over in the back of a vehicle. I bring that up to say that going to law school was really helpful in that, because I was currently clerking for the lawyer who's representing me pro bono in that case. But also that even if you do have an experience going to law school and you get a professional degree, we know that regardless of what you do in your life, these types can really concern themselves around you. I thought that having the experience of being able to talk to police officers and say what you're doing is wrong here, and you shouldn't have stopped me here, and you shouldn't be doing this right here, it didn't help me in that case. And so regardless, I think that it's very important to have multiple approaches to change, and the law is just one of those pieces. Organizing is another. Civic engagement and voting is another one of those, but working in concert together, I think that you can make the change that you seek. And with the law, you can really affect change with those people who are closest to you. So that's why I wanted to go to law school after having, this background in public service, after having this background in social justice work. I just saw the law as one additional piece to be able to move the communities and to also move the work that I wanted to see. And the final thing that I'll address there is that, some people, a lot of times you go to law school and they're talking about corporate, or you want to go big law, and this is what you need to do to go there. But there are so many different opportunities within the law. One of those is public service. So a lot of schools have public service fellowships available that will allow you to do work over the summer for organizations that may not be able to pay you a salary or pay you big bucks to work over the summer. And those public service fellowships can really help assist with that. I received 2 in my time in law school, and in both summers I worked for the Campaign for Youth Justice in Washington, D.C. from Arkansas. And this most recent summer, I worked based out of St. Louis, but I was in Arkansas the whole time because it was remote, for Arch City Defenders, which is a very, Arch City Defenders is a holistic law, social justice law firm that really, they support a lot of indigent clients and people who are trying to break down prison walls and actually tear down some of their prisons in St. Louis, which they were really successful in doing that. And I say that because public service actually helped me get to DC one summer, work for this organization. And at that organization, we had the opportunity to go to different events, go to the US Senate, the US House, record, write up things that happen in these meetings. And one of the meetings that I ended up going to was the Justice Roundtable, which is a roundtable around children's issues with the law, really supporting juvenile justice issues. And that's where I met today's actual guest speaker, Nkechi Taifa. Nkechi Taifa is the author of the new best-selling memoir, Black Power, Black Lawyer, My Audacious Quest for Justice. She is the founder, principal, and CEO of the Taifa Group, LLC, a social enterprise firm whose mission is to advance justice. The Taifa Group's portfolio of clients include coalition building convenings, government relations, meeting and retreat facilitation, strategic and trainings. And as I said, she also convenes this Justice Roundtable. So I see that she's here today, and I want her to have all of the remainder of the time. We've been told today that if you have questions, they will be answered throughout the remainder of the conference and not at the end of this session. So that Nkechi will have the time that she needs to really convey why she thinks law school is great for you and some of the things that she learned throughout that process.
Prospective Black law students, I am really honored to be a keynote speaker for this phenomenal pre-law conference. Thank you, Marion. Thank you for that wonderful introduction. And you indeed have an amazing story. And I really want to thank the phenomenal attorney, Evangeline Mitchell, for inviting me to present at this auspicious affair. So, people often ask me just what it is that shaped and molded me into the lawyer that I am today. I really don't know, but it might have something to do with being born the year the legendary Brown versus Board of Education decision. Yeah, y'all, old school, okay. It was nearly 1 year before Rosa Parks defied the laws of this land and was ungraciously jailed. It was 5 months before the body of Chicago's 14-year-old Emmett Till was found at the bottom of Mississippi's Tallahatchie River. It was 8 years before the indomitable Fannie Lou Hamer determined to register to vote. I've spent my entire career as an advocate for justice, and I knew I wanted to be a lawyer. Why? Well, one of the reasons why is that there was a poster tacked to the bulletin board of my junior high school's Black Studies classroom. This was during the time when Black Studies was first coming into the schools. It was a poster of a Black man with a black beret on his head, with a spear in one hand and a rifle in another hand, sitting in a Grand Slam wicker chair. And all the teenage girls in my class were buzzing about how fine this brother was. Okay. But I kept wondering why he was in jail. And even more importantly, why was Huey P. Newton, the leader of the Black Panther Party, represented by a white lawyer? Granted, it was a progressive lawyer. Yeah, it was a radical lawyer. Yes, a movement lawyer. But where were the Black lawyers to represent the Black people? I wondered over and over again. So around age 15 or 16, I'm in high school, and I remember every week endured in my signature style. I had tight bell-bottom jeans, platform stack heels, a midriff tube top, a huge towering gele, it's an African head wrap on my head, gold hoop, huge earrings, racing to catch the bus down Georgia Avenue, past Howard University to the Black Panther office, which at that time was a storefront located on 7th Street Northwest. And the brothers and the sisters are carrying on these PE, that's called political education, classes in the larger back area. I, however, usually stayed in the front office, sitting on the lap of the cute dude named T, who was pulling security. Yeah, pulling security, and I'm up here sitting on his lap. But anyway, every Saturday, I used to go with the brothers and sisters downtown in front of Soul Shack record store on F Street, or in front of this little earring store on G Street, and help sell the Black Panther paper. So, one hot afternoon, I sat down on the curb and I opened the paper to the Panthers 10-point program, what we want, what we believe. And the graphic assertion of point number 3 particularly grabbed me. It said, we believe that this racist government has robbed us, and we are demanding the overdue debt of 40 acres and 2 mules. Now, I don't quite know just where the 2 mules came from. I always thought it was 40 acres and a mule. But the absence of payback for slavery, it continually flustered me, because even at that young age, folks, I knew that Black people had been kidnapped and brought to this country to labor for free as enslaved people, that we were stripped of our language, our culture, our religion. We were raped, we were tortured. We were then subjected to a Jim Crow era of lynchings and police brutality and inferior education and mediocre health care, substandard housing, and the list goes on and on. But you know what? I ain't know nothing about the Rosewood, Florida, or the Tulsa, Oklahoma, or the Wilmington, North Carolina, or the Elaine, Arkansas race massacres, and who knows how many more. I didn't know anything about the merciless experimentations on defenseless Black women devoid of anesthesia, which led to modern day gynecology. I didn't know about the enormous profits from the enslavement era made by corporations and insurance companies and the banking and the investment industries and academic institutions. But you know what? On a psychic level, I could feel in my bones the enslavement era's inhumane cruelty to Black children, its destruction of kindred ties, exploitation, cultural deprivation, and there was an incessant gnawing in my soul for amends and for redress. So from those early days, I was passionate about injustice, felt that the issue of reparations to be reasonable and fair, and I vowed to talk about the concept whenever or wherever I could. My analysis, however, had not crystallized beyond a check, but just to mouth the word reparations was a starting point to its validity. Let's talk about it, I did, despite my views often being ridiculed or rejected or otherwise summarily dismissed. So standing on that street corner that afternoon, some 50 years ago, little did I realize that I would one day be in the company of leading academicians, economists, historians, attorneys, psychologists, psychiatrists, politicians, y'all, okay, and more, both domestically and internationally, promoting the right to and the need for reparations. Now, I also remember reading in the Black Panther newspaper back in the day about the 1969 assassination of Chicago Black Panther leaders Fred Hampton and Mark Clark in their beds, and the lies and the fabrications of the police department afterwards to cover up the assassination. You see, 50 years ago, I knew about the Panthers because they made the front page news, but I didn't know about the horrific 1857 Dred Scott decision, where a U.S. Supreme Court justice stated that a Black person in America had no rights, which a white person was bound to respect. 50 years ago, I didn't know about the 1822 trial of freedom fighter Denmark Vesey, who masterminded one of the most elaborate slave insurrections in history. I didn't know about the case, libelants and claimants of the schooner Amistad, where in 1841, international law was applied in a domestic court in the United States and served as a springboard to release kidnapped Africans. I knew nothing of the trumped up court trial of the Honorable Marcus Garvey or the inflammatory case of the Scottsboro Boys. And I surely had never ever heard of the phenomenal Black legal giant Charles Hamilton Houston and his cautionary tale that if a Black lawyer was not a social engineer, he or she was nothing more than a parasite on society. But in high school and college, I did study about and I learned and I lived through the cases of Ben Chavis and the Wilmington 10 who were framed for a bombing of a grocery store in North Carolina. The case of the RNA 11 who in 1971 were herded through the streets of Jackson, Mississippi, half naked, barefoot, and in chains, people, for exercising self-defense after their official residence was attacked. The Attica brothers case, where a prison in upstate New York erupted because the state refused to provide prisoners with basic human needs and then turned around and murdered both the prisoners and the hostages. I talk all about this in my book, Black Power, Black Lawyer, My Audacious Quest for Justice. You see, I knew about the case of Angela Davis with her characteristic huge afro and her clenched fist. But rather be fascinated by the allure of Angela, I was mesmerized by the person she was in love with, George Jackson, and his writings, the prison letters of George Jackson, Soul Dad, Brother, Blood in My Eye. And I was curious as to what possessed his 17-year-old brother, Jonathan, on August 7th, 1970, to bust into the Marion County Courthouse with shotguns and rifles that were legally purchased by Angela Davis and pronounced, all right, gentlemen, I'm taking over now, and the massacre that occurred afterwards. I was touched by Ruchell McGee, whom hardly no one remembers today. Ruchell, a prisoner who just happened to be in the courtroom that day as a witness in a trial. Ruchell, the sole survivor of the August 7th courthouse massacre. Ruchell McGee, who is still in prison in California today. Ruchell McGee, the co-defendant of Angela Davis. You ever heard of him? He is past the 60-year incarceration mark behind bars because he had already been in prison before the 1970 incident. I talk about all this because this is stuff that is kind of like swept under the rug. We hear about the sensational, but we don't hear a lot about the very real, ordinary, everyday people behind the sensational. My college days during the mid to late 70s were the days when we as students were immersed in issues involving the divestiture of corporations doing business in apartheid South Africa and trying to educate actors and athletes to support the cultural boycott of South Africa. This was the time of repressive law enforcement legislation in DC, such as no knock, where the police could virtually knock down your door without a warrant. Hello, Breonna Taylor. It's still going on today. And it was the time of the FBI's once secret counterintelligence program, codenamed COINTELPRO, against the Black movement, targeting people from Martin Luther King to Stokely Carmichael to Malcolm X, Muhammad Ali, the Black Panther Party, just to name a few. In the FBI's own words, the purpose of the COINTELPRO was to expose, disrupt, misdirect, discredit, and otherwise neutralize the activities of Black nationalist organizations and their leaders and their spokespersons and the membership and their supporters. And we didn't really rap in those days, or spoken word or whatever. But permit me to share an excerpt from a piece I penned back in the day, and I often recite it. COINTEL's got Blacks in jail. They open up our mail, tap our phones and kick our bones and railroad us to jail. Angela Davis, Reverend Ben Chavis, Assata and Geronimo too. Ruchell McGee all wanted to be free from you know who. FBI went so low they invented COINTELPRO to stop the rise and fire of a Black messiah who could unify and electrify Black people to revolutionize. Co is for counter, which means to use against. Intel is for intelligence. Pro is for program. They thought it was the perfect solution. Counterintelligence program to crush the revolution. Geronimo Gijaga Pratt was in prison during this time. He was a former officer with the Black Panther Party. And one of the main reasons Geronimo was in prison was because he could not provide an alibi to his whereabouts at the time a white woman, was being murdered on a tennis court in Santa Monica. Well, he had an alibi. He had a stone solid alibi. He was attending a Black Panther meeting at the time over 200 miles away. But you know what? None of that came up in court. Why? Because of COINTELPRO, the Panthers were at each other's necks. Geronimo himself had been excommunicated by Huey Newton, who ordered that no one assist him in his trial. But even more sinister, people, even more sinister, was the fact that the U.S. government itself knew and could prove that Geronimo did not commit the Santa Monica tennis court murder. Yet, the FBI refused to provide that evidence to the defense. You see, because of COINTELPRO, wiretaps were made and kept of all meetings of Black Panther Party. And the meeting Geronimo was at during that fateful day was no exception. But you know what? It took a judge, Walter Dickey, nearly 30 years later, people, nearly 30 years later, a judge who might have been a child or a teenager at the time of Geronimo's first trial during the early 70s, to look at all of the evidence and finally set him free. I talk about that in my my book as well. While in prison, oh Lord, while in college, ooh, maybe that's a Freudian slip. While in college, I worked on the legal defense fund and became chairperson of the National Committee to Free the RNA 11. 11 men and women, one of whom was only 15 years old at the time, who were part of a group calling itself the Republic of New Africa, which advocated for the creation of an independent Black nation state in the South. And if you never heard of it, Google professors such as Attorney Derek Bell and Dr. James Turner were on the letterhead of the defense committee I organized. If you never heard of them, Google them. Derek Bell. Oh, I'm leaving you some breadcrumbs here, y'all. Congresspersons back in the day, such as Ronald Dellums and Charles Diggs and John Conyers, political scientists such as Dr. Ron Walters, cultural icons such as Hakeem Madabuti, the list goes on. They all linked their names to this National Committee to Free the RNA 11, which I chaired while a student in college. And so while working on the legal defense, I visited some of the most notorious prisons in the US at that time, including the infamous Marion Penitentiary in Marion, Illinois, Leavenworth Federal Penitentiary in Kentucky. I met with Imari Obadeli, one of the leading defendants in the case, the president of the Republic of New Africa, who after his release from imprisonment went on to receive a PhD and later became a professor. In fact, I just found out that he was one of Attorney Evangeline Mitchell's professors when she was at Prairie View College. I said, oh. I met with Sundiata Akoli, in prison since 1973 when the car he and Sister Assata Shakur and Zayd Malik Shakur were traveling in was stopped after being racially profiled on the New Jersey Turnpike. Again, breadcrumbs, Google it up if you don't know. Check out my book if you don't know. I was visiting folk in prison in the same institutions with the legendary Rafael Cancel Miranda, one of the 5 Puerto Rican nationalists who was convicted back in the 1950s of shooting up the U.S. House of Representatives in protest of U.S. policy in Puerto Rico, whose sentence was later commuted by President Jimmy Carter. Leonard Peltier, the Native American who still languishes in prison today. Shame on our great brother, President Barack Obama, for not commuting his sentence to time served. There is no excuse. And while in law school, Marion, of course, I joined BALSA, the Black Law Students Association. Back then it was called the Black American Law Students, but we dropped that A, And I began to ponder the intellectual challenges. How can we stimulate the ability to invent new ways by which the law can address the wide variety of substantive issues facing today's society? What was needed, I surmise, were strong, innovative lawyers who were not afraid to think outside of the box, to achieve change. I knew that I would not be a lawyer who would be chained to a desk, because I nurtured a penchant for the cutting edge. And as an inspiring lawyer, I felt the responsibility to use the research, the writing, and the advocacy skills that I was learning to challenge injustice. In the course of confronting injustice, I've been arrested 3 times, okay? The first in front of the South African Embassy in protest of continuing apartheid. The second in front of the Longworth House Office building, congressional building in support of statehood for the District of Columbia. The third in Lafayette Square across from the White House, when now it's called Black Lives Matter Plaza, okay? In support of restoring democracy to Haiti. And y'all, if it wasn't for the fact another breadcrumb of Haiti's Toussaint Louverture and Dessalines and Christophes, the fact that they beat France's butt, France, the country of France, their butt back in the day, the U.S. would not have been able to double its size with the Louisiana Purchase. But that's a story for another day. But each time these arrests were en masse, they were staged, the organizers having negotiated with the police and the prosecutors in advance of the demonstrations, making sure that plastic cuffs would be used and all the charges would be dropped. And, you know, after each dismissal, I gave not a second thought about the arrest. And I went on with my life with the inconvenience of maybe several hours until processing was completed. But let me be perfectly clear. My staged arrest and momentary deprivations of liberty were a far, far, far cry from the terror, from the dogs, from the fire hoses, from the nooses of yesterday. I can engage in these struggles, however, because my predecessors were on the front line battlefields of justice, and they sacrificed, they struggled, and they paid the price for a new generation to pick up the baton and struggle against new manifestations of injustice. Thank you, Black Lives Matter. Thank you, Movement for Black Lives. Thank you, Law for Black Lives, and the new generation of freedom fighters today for picking up our batons and continuing the struggle. And I thank the legendary Congressman John Lewis for letting the streets meet the suites in his orchestration of a historic sit-in of Congress protesting Trump's policies. I've done a whole lot over the years as part of what we call the movement. And I often wonder what my niche in the law would be. Would it be education and youth? Would it be employment discrimination? Would it be police brutality? What about academia? It ended up being a little bit of all of those with a specific emphasis on criminal justice. For decades, trust me, a thankless, unpopular, and totally misunderstood error. And as a staff attorney for the American Civil Liberties Union's National Prison Project during the mid-'80s, that was actually my first job out of law school, I often cited in my conditions of confinement briefs Chief Judge Warren's notable 1957 quote in the case of Trop versus Dulles. His statement heralded the importance of continuing, quote, the evolving standards of justice, the evolving standards of decency that mark the progress of a maturing society. And, you know, that meant a lot to me, that, you know, these standards, they evolve. They don't stay back where they, you know, were back in the day. They don't stay back with the 1857, 100 years earlier, a Black person in America has no rights, which a white person is bound to respect. You know, they evolve, okay? And during the height of the war on drugs, unnecessarily long sentences were robotically meted out with seemingly callous abandon. Shocking punishments over the past 30, 40 years of 10, 20, 30 years and life imprisonment for drug offenses was commonplace. Such punishments should offend our society's standard of decency, but they have not. In 1991, the Supreme Court in the case of Harmelin versus Michigan ruled that mandatory life imprisonment for a first-time drug offense did not violate the 8th Amendment's prohibition against cruel and unusual punishment because although the punishment was cruel, it was not unusual. That's some sugar boogie. The punishment was cruel, but it was not unusual, so it does not violate the Constitution because it had to be unusual. That was ludicrous, and it really left me flabbergasted. The twisted rationale reminded me of the Supreme Court case of McCleskey versus Kent, decided a few years earlier in 1987. There, the court declined to provide relief in a death penalty case despite overwhelming evidence of racial bias because the justices feared that the floodgates will be open to widespread racial challenges in other parts of the criminal sentencing as well. So they couldn't give relief in McCluskey case because they say if we do this in this death penalty cases, what about all of these other cases? We don't want to open these floodgates. So lengthy sentences are cruel, but they are usual. Systemic racism exists, but that is the norm. But again, chattel slavery was cruel and usual, yet it was overturned. Jim Crow was cruel and usual, yet statutes were overturned. Lengthy sentences for drug offenses are likewise cruel and usual and meted out disproportionately to people of color. They must also be eradicated. Fortunately, there is national attention today to issues involving the criminal legal system, and this represents an unprecedented opportunity to undertake a re-examination of the U.S. system of mass incarceration, an examination of the system of enslavement, which, as Brian Stevenson of the Equal Justice Institute tells us, did not end in 1865, but evolved into a legacy that can be seen in the presumption of guilt and dangerousness assigned to Black folk, which has led to mass incarceration. Year after year, decade after decade, century after century, although the players change and the scene shifts, the script irrefutably remains the same. Unequal justice. Doesn't matter whether the issue of vigilantism or police brutality or prosecutorial abuse or unjust sentencing as a race. We as Black people have been subjected to a double standard of justice. The names and the groups and the events spanning the decades are Legion, Eleanor Bumpers, Michael Stewart, Amadou Diallo, Abner Louima, Johnny Gamma, Troy Davis, Oscar Grant, Trayvon Martin, Michael Brown, Eric Garner, Ayanna Jones, Freddie Gray, Rekia Boyd, Sandra Bland, George Floyd, Breonna Taylor, Albert Arbery. The damn list is endless. Ms. Pearl thought that what was happening with the police was justice, where in actuality, it was just us. So over a quarter of a century ago, when the 1994 crime bill passed, that was the crime bill that I was walking the halls of Congress 9 months pregnant, fighting against trying to 13-year-olds as adults, the elimination of Pell educational grants for prisoners, the evisceration of the exclusionary rule, the gutting of habeas corpus, the trying of 13-year-olds as adults, the refusal to address the crack powder disparity, and more money to states to build more and more prisons, to lock up more and more people. Woo! So during that time, just after that bill passed, a news item happened to catch my eye. And it stated that a prominent securities analyst in Virginia, he spent a weekend combing through every detail of that federal crime bill and watching the debate in C-SPAN. And he came up then with a list of theme stocks for the 90s. And his highest recommendation went to a company called the Corrections Corporation of America, CCA. At that time, the nation's most successful operator of private prisons. And he said the crime bill was very favorable to us. Why? Because it smacked me in the face that we have a situation where the deprivation of liberty is powered in large part by the profit motive. We have a situation wherein there are economic interests in keeping sentences harsh and long so that prison populations continue to score. And the scary thing about all this is we have a situation wherein the prison business industry may seek to maintain high occupancy rates, even in the absence of demonstrated need. So it's past time that we confront these disastrous policies of the past half century. Today, there are over 2 million people behind bars, and the crisis today is unprecedented, with nearly 200,000 prisoners nationwide having contracted the coronavirus, with only over 1,300 deaths, 37,000 correctional officers testing positive, 78 of them have died. You cannot socially distance in prison. Hand sanitizer is considered contraband because of its alcohol content. Only massive reduction in this over-incarcerated population can stem the side. Let me just say, this country's mammoth experimentation and mass incarceration has been an abysmal failure, producing conditions of life calculated to bring about the destruction of her race. Kudos to Michelle Alexander for popularizing the analogy of today's system of mass incarceration with earlier systems of social control, such as Jim Crow. Yes, we are talking about the institutionalization of second-class citizenship once one is released from prison. Yes, we are talking about disparate treatment and profiling, arrest, and sentencing. But you know what? We may also be talking about the extermination of generations as well. Although enlightening, we must not get too comfortable with Alexander's Jim Crow analogy to mass incarceration, because guess what? It may be too limiting. I say that we must push the envelope even further to illuminate the severity of the problems confronting Black communities. You see, I coined the arguably contentious phrase institutionalized genocide as a framework through which to analyze the evolving jurisprudence of international human rights doctrine to selected conditions impacting Black people in the United States. Institutionalized genocide. The terminology is neither radical ranting or rank rhetoric. Rather, it methodically uses the international and U.S. adopted definition of genocide as a lens to scrutinize today's criminal punishment system and its impact on Black communities. You see, this is why being a lawyer as a Black person is so very pertinent. With the American Constitution Society, I published my article several years ago where I explained my concept, racism in the criminal justice system, institutionalized genocide, if I had not been credentialed as a lawyer. I'm going to just skip some of this, but Google it up. American Constitution Society, Nkechi, Taifa, institutionalized genocide is there somewhere. But we're today witnessing the dawning of a new day, a new era, and we all are a part of this. Marion mentioned the Justice Roundtable that I convened. It's all a part of this. The preface to my book, Black Power, Black Lawyer, begins with a heartwarming question for my then 4-year-old daughter. Mommy, did you get Rosa Parks out of jail? And I say, no, baby, I was just 1 year old when Rosa Parks went to jail. But there was a movement, my sisters and brothers, that not only got her out of jail, but put a set of circumstances in motion that changed the landscape of America, and that was Black Power. And as I come to a close, I would like to take just a moment to embellish on a story that Malcolm X often related about two types of enslaved people on the plantation back in the day, which he described as the house slave and the field slave. I don't know if any of y'all are familiar with that speech, but Google it up, okay? And some, he told us that the house slave lived up there in the big house with Massa. Actually, it was in the attic or in the basement, but it was in the house nevertheless. He ate the same food that Massa ate, or at least it was the crumbs from the table. He was satisfied with that. Massa got sick. He said, well, what's the matter? What's the matter, boss? We sick? And Massa's house caught fire. The house slave fought harder than Massa to put it out. Now, there was the field slave. Malcolm said that he worked in the field from can't see in the morning to can't see at night, lived in a shack, if that, wore gunny sacks for clothes. When Massa got sick, the field slave, he prayed that he wouldn't recover. When Massa's house caught fire, he what? He prayed for a strong wind. But Malcolm didn't mention another one who was out there on that plantation, the yard hand. You see, the yard hand came from the field, but by hook and crook, he succeeded in getting himself away from it. Now, the yard hand didn't live up there in the big house, but she was close enough she could look in, and sometimes got so close that she could sneak in, Barack Obama and Kamala Harris. But she didn't live too far from the field either. She could hear the whip of the lash, and she remembered this thing. You see, the yard hand could see what was happening up there in the big house, could see what was happening in the field. You see, my brothers and sisters, because of her and his unique position, she often had a choice as to whether her position was going to be, was she going to work in the interest of her people? Check out Sonia Sotomayor, Supreme Court Justice, brilliant dissent several years ago in a Fourth Amendment case, or was she going to work against those interests? All right, Clarence Thomas, who essentially flushed the exclusionary rule down the toilet. And bringing it on down to today, was she going to end up being a handmaid, Amy Coney Barrett, or a heroine, Ruth Bader Ginsburg? So law students, prospective law students, the choice the yard hand had yesterday is the exact same choice that you as future lawyers have today. You have the choice to work against your best interest, or you have the choice to actively promote justice. And this choice is present, whether your practice takes you to the apex of the most lucrative law firm in the country or to the most modest legal service provider organization, no matter where your career path takes you, you have the responsibility to put the research, the writing, the advocacy skills that you're learning in Evangeline Mitchell's Blackprelaw Conference to struggle against injustice in society and reach back into the community to assist those who never made it out of the field. I would love for you to go into public interest law, but I would also love for you to be a judge. I would love for you to be a prosecutor. Oh yeah. I would love for you to be a legislator. I would love for you to be a partner in a huge law firm. Why? Because you might be that judge to finally set Sundiata Akoli free, or Mumia Abu Jamal, or Bushel McGee. You might be that prosecutor who uses her discretion wisely. You might be that legislator to abolish mandatory minimum sentences. You might be that governor to grant clemency to Assata Shakur. You might be that law firm partner who finances the posting of bail for any Black Lives Matter protesters to get out of jail. Blackprelaw Conference, I'm closing now. I'm not promising that your journey will be easy, but whenever times get hard or whenever you feel stuck, I want you to remember the words of the great warrior woman, Harriet Tubman. She led over 300 people out of enslavement. She said, keep going. She said, if you hear the dogs, she told her people to keep going. If you see the torches in the wood, she said, keep going. If they're shouting after you, keep going. Don't stop. If you feel tired, keep going. If you want that taste of freedom, keep going. If you want that law degree, Blackprelaw conferees, keep going. If you want to land that clerkship, keep going. If you want to be a partner in a law firm, keep going. Don't stop. If you want to represent the political prisoners, keep going. If you want to mobilize for reparations, keep going. And if you want to carry on the tradition of the movement lawyer, all I got to say is keep going, keep going, keep going. Right on.
Wow, that was amazing. Thank you so much. I think we might be just a bit over time. If y'all have any questions, first of all, there were a lot of links posted about a lot of the resources that Nkechi spoke about today, including her book and her article. So please take a look at that. But thank y'all for being here. Keep going, and we hope to see you as those movement lawyers or whatever lawyer type you choose. Thank you again, Nkechi. Thank you to the conference. We appreciate being here.
Thank you very much.